Hello guys, welcome back to the channel. You know that due LLB semester exam going on, and today it was concluded second semester exam, and today's last paper of international law, paper number LB 205, semester second 2022. Let's see the instruction. I hope you are aware about the instruction of semester examination. There are 8 questions. Out of 8, you have to attempt 5 any question. Every question carries 20 marks, total marks 100, and time 3 hours. But recently, protest was happened against due LLB faculty of law due to the shortage of time between the commencement of exam and semester classes. That's why protest was done. Then after we got only half an hour extra to the time, so we have given 3 hour and half an hour. Okay, let's see the question. The first question is related to the first case of syllabus, reparation for injuries suffered in the service of United Nations. Case was 1944. The International Court of Justice decided this case. This case was related to the reparation, that means protection, being a international identity or entities or international legal personality. You will given certain rights and duties under international law. That's why this case citation is reparation for injuries suffered in the service of the United Nations, 1949. This case was related for the reparation seeking by United Nations for their personals during performing duty. Personnel of United Nations. There were various personnel of United Nations were assassinated by another country. That's why United Nations seeking for reparation. In this case, International Court of Justice observed the legal status of United Nations and held that because of United Nations is a subject of international law, that's why United Nations is entitled to get reparation. So this case judgment delivered by ICJ in favor of United Nations. So this was the crux of this case. You have to elaborate because this question was related to the observation of United Nations, ICJ. The observation was the subject of law in any legal system are not necessarily identical in their nature or in the context of their rights, and their nature depends upon the needs of community. Discuss the legal personality of United Nations in the light of the above observation. This question is for 20 marks, so you have to write minimum 6 pages. First of all, you have to define what is international law, what is the subject of and the status of subject of international law, then define the reparation and form of reparation, and come to the observation and case fact and judgment of the ICJ. Then after it will be concluded your answer. So next question is, the International Court of Justice concluded the following in the case North Sea Continental Shelf case 1969. It was concluded that the Geneva Convention was not in its origins or inception declaratory of mandatory rules of customary international law, enjoining the use of equidistance principle for the delimitation of continental shelf areas between adjacent states. Neither has its subsequent effect been constitutive of such a rule, and that state practice up to date has equally been insufficient for the purpose. Elaborate. So this observation was related to the continental shelf cases 1969. In this case, the fact of this case was related to the delimitation of continental shelf area, and the party name was Germany and the Denmark and Netherlands. The dispute arises when which principle of delimitation continental shelf should be used. There are two mainly major principles to determine delimitation continental shelf area. One is equidistance and second is doctrine of equitable shares. So in this case, three major country, first is Germany and two another is Denmark and Netherlands. So Denmark contended that the principle of equidistance should be used to determine delimitation of continental shelf area, but Germany refused that contention of Denmark and said that no, equitable shares should be used to determine delimitation continental shelf area, because while using the equidistance formula, Germany get loss. I will show the graph why Germany refused the contention of Denmark. Let's see. I am going to do this is Germany. Wait guys, let's see the guys graph. I have drawn the graph for make understood you. This is the area boundary of Germany. This is the boundary of Denmark and Netherlands. According to the Denmark contention, it should be the line between the major country. Denmark, the principal contended that equidistance, and Germany contended that equitable share. According to the Denmark contention, it would be line between the major country. The equidistance principle says that draw the line between the nearest point of two country. That this is the last point of Denmark and this is the last point of Germany. Then divide between the equal distance. It would be the line of equidistance formula. And if you use the formula of equitable share, this shows the equality between the two, like the distance and using the area by two major country, you see that this principle shows the equality between the two countries by drawing this line zigzag. Okay, so Denmark contended that equitable distance formula should be used, equidistance formula should be used, and Germany contended that after disputing the contention of Denmark, no, it should be used equitable share. Denmark contention was related to the Article 6 of Geneva Convention. I think it was done in the year of 1958. Guys, you need to check cross check, guys. I am not sure about the year of Geneva Convention. According to this article says that when you want to delimitation contentional area, delimitation continental shelf area, you need to use the formula equidistance. But during Geneva Convention, Germany was not ratified the convention. So ICJ held that because of Germany was not ratified the Convention of Geneva, so we can't impose the provision of Geneva Convention over the Germany. So ICJ held the judgment in favor of Germany and said that equitable share formula should be used to determine delimitation of continental shelf in this case. So this was the fact judgment of the North Sea continental shelf case between Germany and Denmark, Netherlands. So guys, it was the case of North Sea continental shelf, and I have done with the fact, issue and decision. We have to write these three and elaborate especially in the relation with the conclusion of International Court of Justice. Next question. Elaborate the following: treaty making and rectification in India, role of judiciary in implementation of the international law in India. You have to define what is the treaty as per the article of convention, Vienna Convention. Article 2 and 3 is relevant for this question. And what is the process to make the treaty came into force? There are various processes, approximately 5 processes to make the treaty. You have to write that, and the ratification of the treaty in relation to India. The main ingredient to make treaty is the minimum two parties was relevant, and it will be depends upon the state concerned, and it may be drafted as between the states or governments or heads of states or government departments. At instance, many of the most in treaties are concluded as the between the heads of states. Okay, certain rules in the formation of international convention, like first is the accrediting of persons by the contracting states, appointment of representation, negotiation and adoption. Second stage, negotiation and adoption, representative person outer into the negotiation for the adoption of treaty. And third is signature. For the authentication, it was signature by the representative on the instruments mutually exchange between them. Then ratification, very important step. Unless and until it does not bind the state concerned. That's why this process was not done by the Germany in Geneva Convention. That's why judgment was in favor of Germany. Okay, and it was improved by the state on the behalf of representative of concerned states. Next process is accession and adhesion. The accession is a traditional method, but adhesion is the modern method in which the acceptance of either certain aspect of the treaty or consistent principle entertained to it. The next step, sixth step is entry into enforce. The treaty enters into force acceptance within the provision of treaty. Article 14 of the convention said that after ratification the process is entry into force. Next process is registration and publication. A treaty is required to be registered with the Secretary General of United Nations after it has came into force. Article 102 of United Charter says that. The last process is application and enforcement. The last step of the formation of a treaty is its application and enforcement. After a treaty is ratified, published and registered, it is applied and enforced between the concerned party. This is the process for treaty making. Okay, now come to the role of judiciary in the implementation of the international law. There are various provisions of the Constitution of India regarding the international law. You have to look for that, like the fundamental duties, like the DPSP, Article 51, and there are also various articles. You need to Google also for this question. Okay, now come to the next question. International Court of Justice observed in the hostages cases. First of all, write the facts and issue and come to the observation and read carefully the observation of this concerned question and give your opinion and the decision regarding this question. Now come to the another question. Define the continental shelf. Distinguish between continental shelf and the contiguous zone. Explain the rights and duty of coastal states over the continental sheet. So the continental shelf is a category of maritime zone. There are major 5 categories of the maritime zone. First one is territorial sea, second one is contiguous zone, third is economic exclusive zone, fifth is continental shelf and the high sea. These are the 5 major category of maritime zone for the respective coastal states. So for this question you need to define every 5 category. First define continental shelf, then define contiguous zone and draw the distinction between two. You can also draw for this question a graph for the better for the good answer. I am going to show you the graph. Just wait, guys. Yeah, you can see this topic come under the chapter 5. I am telling about the concerned syllabus of public international law provided by Delhi University, Faculty of Law, second semester. Topic 5 cover the law of sea. You know, law of sea was enacted on 10th December 1982. It is a part of international law. It is collection of all international treaties and agreements. It is regulates all marine and maritime activities. It is develop peaceful relationship between the sea and coastal states. It was adopted by United Nations on 10 December 1982, which was effected from 16th November 1994. It codifies the rules and regulations on the freedom of negotiations, which is essential for the national security of every states. So let's come on the let's turn the mic. Let's come on the figure. This is line shows the this is the land. This is so the area of sea, whole area of sea. And now come on the territorial sea. It is extended from baseline to 12 nautical miles. This area called territorial sea. Then contiguous zone. In this question asked, it is extended to 24 nautical miles from baseline of coastal state. Now come to the exclusive zone. It is extended to 200 nautical miles from baseline. Now come the continental shelf. It is extended from territorial sea to a drop of point called shelf break. There is no specific distance granted for the continental shelf. Whenever this situation occurred, it will be decided. So this is the continental shelf and this is the contiguous zone. The difference between you can draw on the basis of the distance, on the basis of the situation, on the basis of the right and duty of the coastal states related to the contiguous zone and continental shelf. You have to do that minimum, and you can also draw this line, this figure, and define one by one and distinguish them, and then come on the last part of the question is that right and duty of the coastal states regarding this continental shelf states. Okay, this was the format to answer the question number 5. Now come to the question number 6. Discuss general principle of law as a source of international law with the help of decisive case. Discuss the general principle of law as a source of international law with the help of decisive case. This is a question regarding the general principle of law as a source of international law. There are various sources of international law provided under the Article 38 of the Statutes of International Court of Justice, and one of them was the general principles. Okay, you have to describe the general principles of law as a source for the international law. Now come to the next question. Explain the importance of General Assembly resolution as a source of law, international law. It is also related to the question of source of law. And write the sanctions and under the international law. There are various sanctions and under international law, like the political sanction, state sanction, economic, financial sanctions, moral sanction, social sanction. Apart from these, Article 38 also you have to write for the source of law and the sanctions. Sanctions mean the penalty for obeying the rules and regulation provided by the international law. So now come to the next question. Question number 8. Write short notes on the following: International Commission, extradition, state immunity, right of innocent passage. So International Commission, Law Commission was related to the international law. It was established in 1947 and it has the 34 members appointed by the United Nations for 5 years, and the appointment of or the selection of the members of the International Law Commission on the basis of equitable distribution, geographical distribution. Now come to the extradition. Extradition is a process by which a criminal or accused taken from the another country which was absconded after doing the crime to the another country. So this was the process of extradition. You can use the name of, there was also a term of asylum. In asylum, for the asylum, now you can take the example of Nirav Modi, Vijay Mallya has done the various activity in our country and currently living the another state. And also in Human Rights Council under Article 14 Clause 1 provided that every person has right to seek asylum from the prosecution of their own states. So this is the thing about the extradition and asylum. Now come to the another topic, state immunity and the right of innocent passage. Right of innocent passage under the Article 17 of Convention regarding the right of innocent passage. Every state has right to innocent passage to follow the concerned state boundary jurisdiction of the municipal law. So there was a case regarding the right of passage. This case was between the Portugal and India. Portugal claimed to seek the right of passage into the dominant due for sending the military, and India refused them, stopped them, because there was a treaty signed between the Portugal and India in 1779, that is 1779, but after that India has got authority over the dominant due and Dadar Nagar Haveli, so that India has power to refuse to enter into the jurisdiction or territory by anyone. So ICJ in this case held that India has not done contrary to the law, and India has power to use municipal law as per their jurisdiction. So this was the brief analysis of the today's paper, Public International Law. I hope you are aware about how is the level of asking question of the LLB semester exam. So you need to prepare well to tackle the question. You have to do question 5 out of 10 as per the recently format of the asking question. So thank you so much for watching this video. I hope this video will help you to know the question of law related to the various semester exam of Delhi University Faculty of Law. If you have any query, you can suggest me, you can put it into comment box, and you can also contact me on Telegram. My Telegram ID is rahulprudent_India. I have also channelized a channel on Telegram, the same name like YouTube channel, Legal Prudent Study. You can search easily and can join. So thank you so much. Have a good day, and if you are preparing for any exam, best of luck.